Let's consider the other reasons that businesses and other users prefer international arbitration as a means of resolving their disputes. One of those reasons is greater expertise and competence. Historically, arbitration was favored by businesses and other users because it offered a more expert, more experienced, more competent means of dispute resolution, a more expert decision maker. We can see observations to this effect in national court decisions. The Supreme Court in Cyprus in 2000 observed that familiarity of arbitrators with their subject matter is among the reasons for which the institution of arbitration has flourished. In the words of one U.S. judicial decision, the arbitrator's expertise are one of the most attractive features of arbitration apart from speed and finality. A former French judge on the Cour de Cassation made similar observations. He commented, for a French party, the big advantage is that international commercial arbitration offers deluxe justice. Instead of having a $600 million dispute before the commercial court in Paris, where each party has only 1 hour for pleadings and where you can't present witnesses and have no discovery. For a dispute of that importance, it may well be worth the cost to get a type of justice that is more international and more luxurious. What you get is more extensive and thorough examination of witness testimony without the excesses of American court procedure. Another observer, again a judicial observer, commented that what you do, we don't have to do. And in many fields, you, the arbitrators, are more professional than we are. Why is that the case? Why is it that businesses perceive arbitrators, international arbitral tribunals, as being more expert, more experienced, more competent than their counterparts in national courts? The reason is straightforward and has to do with the essential character of arbitration, international arbitration, which was non-governmental decision makers chosen by or for the parties in individual cases resolve the parties' dispute. That means decision makers are chosen by the parties based upon their needs, based upon the characteristics of individual disputes. If the parties have an insurance dispute, for example, they can choose arbitrators with expertise in insurance law. If the parties have a construction dispute, they can choose arbitrators with construction experience and experience in construction in the particular geographic region of the world, in the particular economic sector that their dispute arises in. If the parties have an M&A, mergers and acquisition dispute, they can choose M&A experts. If the parties have a dispute about the quality of commodities, they can choose arbitrators with extensive experience with precisely that type of commodity. Parties can choose arbitrators with linguistic abilities. Parties can choose arbitrators with particular credentials as accountants, as insurance industry experts, as experts in oil and gas or some other sector. All of this means that the tribunals, instead of being, as is often the case in national courts, generalists, judges who are required to decide everything from tax disputes to landlord-tenant disputes to criminal or drug law disputes to administrative law disputes to constitutional law disputes, and then occasionally an M&A dispute. The parties can select arbitrators who are precisely qualified in the subject matter of their particular dispute. That almost certainly guarantees that the tribunal will have materially greater experience and expertise than the available alternatives, the alternatives available in national courts. And of course, in some national courts, indeed in many national courts, important domestic political considerations affect the character of national court decision-making. Some countries may, for example, require lay juries, either entirely or in part. Other countries may demand particular types of political qualifications for members of the judiciary. None of that is calculated to produce competent, expert resolution of international commercial disputes. Not surprisingly, empirical research reveals that business users value arbitration, prefer arbitration in part because of the greater expertise that the arbitral tribunal offers. We can see again the Queen Mary University of London study from 2015 reaching this conclusion. Other conclusions, a 2013 study by Queen Mary and PricewaterhouseCoopers reached precisely the same conclusion. Some commentators have made the same observation. In the words of one U.S. commentator, expertise, commercial, professional, or technical, often tops the list of desired attributes for arbitrators. In contrast, most national court systems involve decision makers who lack the experience and expertise to competently resolve complex international commercial disputes. Instead, parties will have their disputes decided by a one-size-fits-all generalist judge without particular international experience, and certainly without specialized experience in a particular economic sector. In many cases, national court judges will lack judicial training. They will certainly lack commercial expertise. And in some cases, as we've seen, they will lack basic standards of integrity. Some national court systems provide competent judiciaries. England, Switzerland, New York are good examples. Even in these systems, however, many judicial systems have local idiosyncrasies, whether jury trials, excessive discovery, other types of idiosyncratic local procedures such as split professions. All of these aspects of national court proceedings are ill-suited to international dispute resolution. In contrast, in most substantial international arbitrations, arbitral tribunals will consist of 3 members, 3 arbitrators chosen specifically for their expertise after a dispute has arisen, their expertise in resolving precisely that type of dispute between precisely the parties who are involved in the arbitration. That offers vastly greater assurances of expertise and competence than the random assignment of judges who are typically generalist judges without specialization in individual cases. International arbitration also offers enhanced finality. In particular, most arbitral awards are not subject to appellate review. Most arbitral awards are not subject to review for errors of fact by the arbitral tribunal or for errors of law by the arbitral tribunal. Instead, in most cases, an arbitral award may be annulled or set aside only on very narrow, specifically defined jurisdictional grounds. The arbitral tribunal lacked jurisdiction or exceeded its jurisdiction, or procedural grounds. The tribunal committed some gross procedural irregularity or unfairness. In a few cases, there may be public policy or non-arbitrability grounds for setting aside an arbitral award. But apart from these very limited exceptions, arbitral awards are final and binding. They are not subject to appellate review. In contrast, in most national court systems, first instance judicial decisions are subject to appellate review. In many cases, quite rigorous appellate review, particularly on issues of law. In some jurisdictions, the appellate review is de novo review. This appellate review necessarily leads to substantial additional cost and substantial delays. The first instance decision may be set aside and the trial ordered to be retried. Parties may have to expend money not just on one litigation, but multiple litigations depending upon the outcome of appellate proceedings. In contrast, arbitration offers a single centralized dispute resolution mechanism without the risk of second guessing by appellate tribunals. Naturally, this means that arbitral awards which are wrong or perceived to be incorrect will not be subject to recourse in many circumstances. Parties will be forced to live with what they regard as an incorrect judicial decision. The risk of incorrect decisions, however, is directly and well addressed by the very characteristics of international arbitration which we have just considered. Because the parties are able to choose expert decision makers, precisely qualified to resolve their dispute. And because in more substantial matters, tribunals consist of 3 arbitrators, not a single arbitrator, where the separation of law and fact is avoided. The arbitral tribunal simultaneously develops the facts and the legal principles of the law. All of these lead to greater accuracy, greater correctness of the arbitral process, thus reducing the possible costs of a lack of appellate review. Empirical studies from around the world indicates that businesses prefer the efficiency and finality of arbitration without appellate review as compared to appellate review in the context of national court proceedings. A Queen Mary study from 2015, which we've previously considered, concluded that a majority of respondents, a substantial majority in fact, do not favor an appeal mechanism on the merits of either commercial or investment arbitration. There's a widespread preference for arbitration as a one-stop shop. We can see, for example, that nearly 80% of businesses responding to the Queen Mary study rejected the suggestion that there be appeals in international arbitration. A substantial majority of respondents also favored the current system in investment arbitration where there are no appeals from arbitral awards. Another one of the reasons for international arbitration, for the preference that businesses and other users have for international arbitration, is the procedural autonomy that it allows to parties. This procedural autonomy is reflected both in actual practice on the one hand and the legal framework for international commercial arbitration on the other hand. We can see, for example, in the New York Convention, Article 5, 1D, provides that one of the grounds for non-recognition of arbitral awards is where the arbitral procedure was not in accordance with the agreement of the parties. This provision reflects the fundamental importance of the parties' procedural autonomy in international arbitration. The same autonomy is reflected in the UNCITRAL model law on international commercial arbitration and other national arbitration statutes. We can see, for example, in the model law in Article 11 and Article 19, subparagraph 1, the importance that is accorded to the parties' procedural autonomy. Exercising the procedural autonomy that is afforded to them, parties in international arbitration, both international commercial arbitration and investment arbitration, are able to dispense with the technical and often idiosyncratic formalities of national court litigation. Parties are instead free to tailor the procedures used to resolve their dispute specifically to the characteristics and needs of that dispute. Parties can agree upon the length and location of the hearings. Parties can agree upon the format of the hearings and the format of both fact and expert witness testimony. They can agree upon innovations such as witness conferencing. They can agree upon the need for, existence, and scope of document disclosure and other types of disclosure and fact-finding in the arbitral process. Parties can also agree on a host of other aspects of the arbitral procedure, all directed at ensuring that the process is designed to produce an efficient, expert, even-handed, and enforceable result in their particular dispute. Business users, as well as other users of international arbitration, cite procedural flexibility, the parties' procedural autonomy, the arbitral tribunal's procedural discretion as one of the key factors favoring international arbitration as a means of dispute resolution. In the words of one commentary on the UNCITRAL arbitration rules, procedural flexibility is generally regarded as one of the main advantages of arbitration. Other authorities are to the same effect. A related and important reason for international arbitration, for the preference for international commercial and investment arbitration, is that it often, not always, provides a quicker and cheaper means of resolving the parties' dispute. A quicker and cheaper means of resolving the parties' dispute as compared to other available alternatives. Litigations in national courts are often subject to substantial delays. In developed jurisdictions within the European Union, for example, Trial court proceedings can take years, sometimes longer. Trial court and appellate proceedings can take decades. That includes jurisdictions both within the European Union and elsewhere around the world. The delays that are occasioned in national court proceedings of this sort often deny the parties real access to justice, while also imposing very substantial costs on both parties. The delays that are occasioned by litigation in national courts have been a feature historically of those systems of dispute resolution, systems which are funded by public fiscal sources and inevitably have limited resources. One Coptic Egyptian source quoted the following observations by an Egyptian litigant. We fought each other before the most famous comes, diocetes, the administrative tribunals of the local district, about a house on Coela Street. After much altercation before the diocetes, he made a proposal on which we all agreed. We elected arbitrators from the castron, and the diocetes sent them into the house, and they made the decision. Simply put, a litigant, exhausted by proceedings in local administrative tribunals and courts, accepted a proposal to arbitrate a dispute over property, and the arbitrators then resolved that dispute quickly and efficiently. The same observations can be found in colonial America. The New York Weekly Postboy, a local publication in 1751 before independence, remarked as follows, "Let me tell you that after you have expended large sums of money and squandered away a great deal of time and attendance on your lawyers and preparations for hearings, one term after another, you will probably be of another mind and be glad 7 years hence to leave it to that arbitration which you now refuse." The author of this observation was frustrated by the unwillingness of his counterparty to agree to resolve their disputes by arbitration, and presciently remarked upon the likely course in national courts were arbitration to be refused. These observations, of course, are not always correct. Arbitration in some cases is not quicker and not cheaper than some alternatives. Contemporary authorities are to the same effect. We can see some examples on the current slide. In the words of one U.S. judicial decision, parties agreeing to arbitrate trade the procedures and opportunity for review of the courtroom for the simplicity, informality, and expedition of arbitration. The House of Lords made similar observations, which we can also see. Some critics have observed that, at least in some circumstances, arbitration can be expensive and slow. In the words of one commentator, commenting on ICC arbitrations, international arbitration is an expensive process. The Queen Mary University study, which we've previously considered from 2013, also remarked that some interviewees have expressed concerns over the judicialization of arbitration, the increasing formality of proceedings, and their similarity with litigation, along with the associated costs and delays in proceeding. It is true that international commercial arbitration, international investment arbitration as well, is not always quick and not always cheap. Major international commercial disputes can take 18, 24, 36 months to resolve. Parties will expend substantial amounts on lawyers, experts, and the other costs of proceedings, including the costs of the arbitrators and the costs of renting premises in which hearings can be conducted. Nonetheless, in practice, international commercial arbitration and investment arbitration provides a more efficient, more expeditious means of dispute resolution than the available alternatives. Again, that is because of the absence of appellate review and because of the parties' procedural freedom, the parties' procedural autonomy, and the arbitral tribunal's procedural discretion to agree upon mechanisms which save time and money. Many arbitral institutions have adopted institutional rules that allow for expedited procedures in smaller value cases. The Singapore International Arbitration Center pioneered expedited procedures for disputes involving less than roughly $5 million, a fast-track procedure that produces an award from a sole arbitrator in the space of 6 months. The International Chamber of Commerce adopted similar procedures recently for small value disputes, expedited procedures which ensure that the dispute will be resolved much more quickly and efficiently than virtually all national court proceedings would permit. It is not just that arbitration avoids the costs and delays occasioned by multiple layers of factual and legal review by appellate tribunals. Arbitration also avoids the costs of scorched earth discovery of the sort that is found in some national legal systems. It also avoids the costs of expensive and slow, as well as uncertain enforcement proceedings for both forum selection agreements and national court judgments. When the full costs of a dispute resolution process are considered, arbitration is typically the cheaper and quicker alternative. It's also important to have regard to the characteristics of individual disputes or categories of disputes when considering the time and cost that arbitration involves. Smaller value arbitrations are frequently resolved very quickly and very efficiently. That is in part because of the parties' procedural autonomy and the arbitral tribunal's procedural discretion. It's also because of institutional arbitration rules, which in some instances permit expedited procedures for smaller value disputes. The Singapore International Arbitration Center, for example, pioneered rules that allow for the resolution of small value disputes of less than roughly $5 million in 6 months by a sole arbitrator. The ICC, the International Chamber of Commerce, recently adopted similar rules. Various arbitral institutions have also adopted procedures for summary dismissal of frivolous claims. All of these ensure that the arbitral process, particularly in smaller value disputes, is expedited and efficient. Other disputes are different. Other disputes are large, very large, complex, and important. The parties care very much about how these disputes are resolved. They devote very substantial resources to the resolution of those disputes. By choice, they devote resources to the resolution of those disputes because it is critical to them that the disputes be resolved as well as possible. As a consequence, in larger value disputes of hundreds of millions of dollars or euro, or billions or tens of billions of dollars or euro, parties wish that the arbitral process be lengthy, not for the sake of taking time, simply to take time, but instead to ensure that the parties have maximal opportunities to present their cases in a dispute which is highly important to both parties. As a consequence, the arbitral process can be lengthy. It can allow for detailed and substantial written submissions, detailed witness testimony at live evidentiary hearings, careful consideration by the arbitral tribunal of a large range of arguments, both factual and legal. These types of proceedings are costly to resolve. These types of proceedings would be costly to pursue in any forum, and they are costly in arbitration. Nonetheless, because of its procedural flexibility, because of the parties' procedural autonomy and the arbitral tribunal's procedural discretion in general, these disputes are less costly and more efficient in arbitration than elsewhere.